to begin. It's my great pleasure to welcome and introduce Professor Brian Tamanaha, who is currently the William Gardner Hammond Professor of Law at Washington University School of Law. Professor Tamanaha has been invited to Queen Mary as a distinguished visiting fellow. He's a socio-legal scholar with an outstanding international reputation. He's the author of 8 monographs, most of which have been translated into other languages. His work on legal pluralism, in particular his monograph, A General Jurisprudence of Law and Society, is a major point of reference for all scholars working in this field. He's also made significant contributions to the study of constitutional theory, legal history, legal education, and the rule of law. His work combines both sociological and philosophical approaches to law and legal theory, including most recently research into the history of law and legal thought. We are extremely pleased that Professor Tamanaha has agreed to give the first lecture in our new annual lecture series in honour of another leading socio-legal scholar, Professor Roger Cotterrell. Professor Tamanaha's lecture is entitled The Future of Jurisprudence. To give you a flavour of what to expect, I can do no better than to quote Professor Cotterrell himself in an extract I've taken from his review of a recent book by Professor Tamanaha. I quote, Tamanaha's previous books have shown his ability to present vivid arguments on large themes of great contemporary interest. He engages provocatively with key debates, typically develops his arguments in a clear, direct prose, and usually reaches strong conclusions that challenge the reader. I think that Roger has given us a sense of what to expect this evening. So please welcome Professor Brian Tamanaha.
Thank you, Richard. Thank you, all of you, for coming. It's my really great honor to be here today to give the Cotterrell lecture. I mean that I met Roger in the early 1990s. We can't remember when, but it was in Amsterdam. And I remember at the time I was just so excited that he was there talking to me. I don't remember much else about the conversation, but ever since then, I mean, it's been just brilliant to know him. This event, I want to say up front, comes with more than the usual pressure to present an informative quality talk. I've given a number of named lectures, but this is the first time the person after whom the lecture is named actually sitting in the audience, and that somehow changes the moment for me. When I gave the Julia Stone address, I wasn't worried about him glaring in me from the front row. But what adds to the pressure for me is that as leading up to this talk, I'm trying to think of how many of Roger's books and articles I've read over the years, and I really can't count them all. I do recall over 2 decades ago when I picked up his Sociology of Law, and I just absorbed the knowledge in that book. I think it's a brilliant book. I've come back to it many years. But then after that, I was, in a very different way, excited about the politics of jurisprudence. Not only because of the jurisprudence information contained, but also because it taught me to look at jurisprudence in a different way, from a different angle. And that followed up with Emile Durkheim and Law's Community and too many other books and articles to recount. I still read him thanks to SSRN, and just a few days ago, I read a terrific essay by Roger on Petrozinski, which is really great, so I highly recommend that to all of them. My point of recounting all of this is I really see myself as a student of Roger's. And like all students, I feel in many ways unworthy of being someone to give this talk. Be that as it may, I'll try the best I can. For these reasons, I'll hesitate to look in his direction, just out of concern he might visibly disapprove of what I have to say, or even worse, yawn a few times out of boredom. Having said that, I'll have some reassurance now that I've expressed my inner fears, because Roger, the gentleman that he is, I'm sure will strive mightily not to show any disapproval and not to yawn. Okay, so the title of my talk is The Future of Jurisprudence. And the inspiration for this talk is a recent essay, or an essay that came out a year ago by Roger, in which the title of which is Why Jurisprudence is Not Legal Philosophy. In the essay, he critically describes the current state of legal philosophy. narrow in orientation, highly abstract, driven by philosophical concerns, and detached from legal practice. Against this, Roger advocates what he calls bricolage jurisprudence, grounded in juristic issues and focused on the social reality of law. As Roger put it, lacking firm methodological commitments, this bricolage jurisprudence has collected magpie-like insights from anywhere they can be found. I heartily agree with the thrust of his essay, and today I propose to take his analysis a few steps further. My lecture will consist of three parts. In the first part, I'll detail why I believe analytical jurisprudence as we now know it inevitably will change, and actually is already changing in ways that I'll suggest. In the second part of the talk, I will map or offer a map of jurisprudence that I believe helps clarify the field in certain respects. And then in the final part, I'll sketch a theory of law that I believe helps us understand new forms that law has been taking in the modern age. In the course of this presentation, just to clarify something up front, I'll use the labels analytical jurisprudence and legal philosophy interchangeably because in my usage, they roughly represent the same cluster of people and ideas. Okay, so let me begin with the first part, why change is coming to analytical jurisprudence. To set up my argument that it inevitably will change, I have to say a bit about its current state, just to set the stage for this. So let me begin with a few passages from Roger's characterization in the article. He writes, legal philosophy presents itself as having a clear identity and strong intellectual underpinnings located in philosophy. Its methods, choice of problems, forms of argument, and criteria of relevance are seen as validated by philosophy as an academic discipline. Indeed, the tendency among many self-identified Anglophone legal philosophers has been to view jurisprudence insofar as it is not legal philosophy in this sense and as unworthy of serious scholarly attention. Roger continues, its typical focus on the universal or the necessary blinds it to social variation revealed by empirical studies of law and society and the resources of social legal theory. Its tendency to see its concerns as relatively independent of those of lawyers in practice and academic lawyers in general isolates it from everyday juristic concerns. So that's Roger's characterization of contemporary legal philosophy. When I read this, it brought to mind an essay written in 1979 by William Twining entitled Academic Law and Legal Philosophy. In the essay, Twining was talking about the impact of H.L.A. Hart. He praised Hart for bringing systematic analysis and rigor to jurisprudence, but he expressed reservations about certain narrowing tendencies already evident in Hart's followers. William wrote, they adopt a rather narrow and recondite view of jurisprudence, and by implication, either to treat jurisprudence as coextensive with legal philosophy or to imply that philosophizing in the Oxford style is the only intellectually worthwhile kind of jurisprudential activity. He continued, notions of what is philosophically interesting may also have a limiting influence. At worst, this may take the form of a kind of intellectual snobbery about what concepts or issues are worthy of attention. Twining was especially critical of their single-minded devotion to conceptual analysis with little attention to how law operates in society. I quote, yet, if law is to be viewed as a social phenomenon, it would seem to be worthwhile at least to explore the relationship between legal theory and social theory, in particular the possible connections between theories of law and theories of society. Now, Twining published this essay 36 years ago, and remarkably, his depiction of legal philosophy then closely matches Cotterrell's depiction today. What Twining expressed concern about at the time has clearly come to pass with a vengeance. Now, lest anyone here thinks Roger and William have been uncharitable towards legal philosophers, let me quote a recent passage from Joseph Raz that supports their characterization. Raz states, since a legal theory must be true of all legal systems, the identifying features by which it characterizes them must of necessity be very general and abstract. It must disregard those functions which some legal systems fulfill in some societies because of the special social, economic, or cultural conditions of those societies. It must fasten only on those features of legal systems which they must possess regardless of the special circumstances of the societies in which they're in force. This is the difference between legal philosophy and sociology of law. The latter is concerned with the contingent and with the particular, the former with the necessary and the universal. Sociology of law provides a wealth of detailed information and analysis of the functions of law in some particular societies. Legal philosophy has to be content with those few features which all legal systems necessarily possess. Or consider this recent statement by Scott Shapiro. Social sciences cannot tell us what the law is because it studies human society. Its deliverances have no relevance for the legal philosopher because it is a truism that non-humans can have law. Science fiction, for example, is replete with stories involving alien civilizations with some form of legal system. Social scientific theories are limited in this respect, being able to study only human groups, and hence cannot provide an account about all possible instances of law. I must admit that I laughed when I read this statement, not because Shapiro was joking, but because he was absolutely serious. When they claim to be after universal truths about law, they mean literally throughout the universe. I will not take time here to respond to Shapiro's argument. I'll just point out that any concept of law sociologists produce, like Weber's notion that law involves the coercive application by a staff to enforce norms, can be applied to analyze excuse me for saying this, an alien civilization should we ever come across one. Weber never made this claim because the idea is outlandish. The quest of philosophers for essential, necessary, universal, timeless truths about the nature of law inevitably results, as Roger says, in highly abstract, narrow observations detached from social reality. This is what they avowedly and proudly pursue. Since, as Twining's essay shows, legal philosophers have been thinking along these times for 4 decades, you might wonder why I'm optimistic or confident that things are about to change. So I'll offer 2 reasons why I believe change is inevitable, and I'll follow this up with a recent indication of the change that I'm describing. So the first reason is that the logic of their position is unsustainable. So let me concisely state the problem that they face. On the one hand, they're seeking to identify essential, necessary, universal truths about the nature of law. On the other hand, they agree that law is a social construction. They acknowledge that, like all social constructions, law is contingent, comes in many variations, and changes over time. These 2 positions cannot be reconciled. Contingent phenomena that come in variations and change over time do not have essential or necessary characteristics and cannot be the basis for universal truth. Frederick Schauer, in particular, and Ronald Dworkin as well, have both argued that while natural kinds like water might have essential and necessary features, social phenomena do not, because they're the product of contingent social beliefs and actions that change. I agree with their critique, but I won't elaborate on that here. Instead, I'll recite a few passages from Raz to show why his argument, I believe, collapses on its own terms. So these passages are taken from his 2009 book, Beyond Authority and Interpretation, which grapples extensively with these issues over the span of several chapters, and 2 focused entirely on this topic. Raz states, "It is easy to explain in what sense legal philosophy is universal. Its theses, if true, apply universally. That is, they speak of all law, of all legal systems, of those that exist, of those that will exist, and even of those that can exist, though they never will. Moreover, its theses are advanced as necessarily universal." This is a very straightforward and very bold declaration. And then after stating this, he veers immediately in a different direction. So here's the next statement. Now this is a couple of paragraphs later. "While the general theory of law is universal, it is also parochial. What makes it parochial," that was a quote. I'm adding, "what makes it parochial, quote, is that the concept of law is itself a product of a specific culture." Again, continuing with Raz, "Talk of the concept of law really means our concept of law. As has already been mentioned, the concept of law changes over time. Different cultures have different concepts of law. There's no one concept of law, and when we refer to the concept of law, we just mean our concept of law." So Raz continues, it follows that in working out a theory of law, we are explicating our own self-understanding of the nature of society and politics. Now this passage, which makes good sense, the second passage, raises this obvious question, well, how do you reconcile that with the first passage? How can a parochial concept of law from one society be universal? His reasoning is that legal philosophers begin with our parochial concept of law in the here and now, and then abstract a way to identify essential and necessary features, then producing from this process a theory of the nature of law. This theory of the nature of law is based on our concept of law, but in an abstracted form. So that's the argument and how he sets it up. But the question remains, what makes the theory produced in this fashion, universal? Okay, now, to explore this issue, I need to make a really important distinction between universally applicable and universally true. If Raz's claim is only that we can apply our concept of law to analyze other societies, that's clearly correct. Any concept can be applied to other societies, past and present, with proper caveats about the source of origin. So you can apply Weber's, and in fact that was the point of creating it, to examine other societies, to ask, did you have a public staff available to enforce norms through coercion? So there's nothing controversial about universally applicable. Raz's claim, however, is not that it's universally applicable only, it's that it's universally true. So here's a quote for that. The universality of the theses of the general theory of law is the result of the fact that they claim to be necessary truths, and there is nothing less that they can claim. So there's a gap in his argument that he never fills. Let's grant that the theory of law he produces is true. It would only be true in relation to the concept of law in which it's based, our concept of law. This doesn't make it universally true. To continue with the alien example, for example, he might tell an alien civilization that according to the elements of the theory of the nature of law produced on our concept of law, their civilization lacks law. Now, obviously, the alien's response would be, well, according to the concept of law based on our concept of law, we do have law and you don't. So here we have two propositions that there can be no response to. We can apply the same thing to Aborigine societies. We can apply the same thing to any context in which this theory of law is taken. The response is, well, that theory of law is based on your concept of law. Our concept of law differs. Now, it gets even more puzzling when Raz makes a claim, and I'm talking about just a span of 2 pages in Authority and Interpretation. When Raz makes this statement, suffice it to say that the truth of the theses of the general theory of law is not contingent on existing political, social, economic, or cultural conditions, institutions, or practices. Now, what's surprising about this statement is that he's already acknowledged that the theory of law is contingent. It's derived from our parochial concept of law based on our society and social understandings. And he says this multiple times. So in one passage, he asserts that the theory of law is based on our parochial concept of law. And yet in another passage, he asserts that the theory of law is not contingent on existing social, cultural, political institutions. If you're wondering how this all hangs together, the answer is that it does not. The abstracting away from our concept of law, what it really does is just embeds our concept of law in the general theory of law, but it doesn't change the source of origin of the concept of law. Now, this is one form in which the logic of the argument doesn't hold up. I'll state another one that's very different, and it's based on the nature of change. Raz states, again in a span of a few pages, that our concept of law is liable to change forever. And change is actually a problem for essentialist concept of law. So just imagine this scenario. 1,000 years from now, the concept of law that we have today is actually changed. And to give you a plausible possibility, people believe that there's inherent right within law. Now, a philosopher 1,000 years hence, we'll call him Raz 3000, would abstract away from that theory of law and come up with elements that include right as a basic element of our concept of law. Raz today wouldn't. These two concepts of law, we'll call them A, B, C, and then in year 2000, A, B, C, D. These two concepts of law, based on existing cultural concepts of law at the time, according to Raz's theory, would be true, universally applicable, and yet mutually inconsistent. From the standpoint of each theory of law, the other theory of law is incorrect. Now, I focused on Raz, but he's not the only one who makes these claims. It shows, let me just give you another example, and I want you to think about the terms in which this is being presented. And this comes from John Gardner. Philosophers study inter alia the timeless necessity of all this contingency. The invariant and universal truth, for example, that law and the idea of law are both equally contingent and variable features of human civilizations, features that might one day perhaps be lost and even forgotten. They are universal truths about a decidedly non-universal thing. What I'm suggesting is that the struggle in these passages to make this all hold together is telling of the fundamental problem that they face. To put it bluntly, universal truths cannot be founded on contingent parochial social constructions. So let me go to the second reason that they'll have to change. The concept of law that they produced is from the outset has been incomplete and then ultimately obsolete. What makes it incomplete is that all along they've assumed there's only one concept of law. The very question, what is law, actually tends to point theorists thinking in this direction. Law is X. When Hart began his inquiry in the concept of law, he identified state law, as the epitome of law because, as he put it, that's what educated people think of law. And he's correct, as far as it goes. But the inquiry should not have stopped there. Had he asked most educated people, at least today, do you think international law is law? They would say, well, sure, that's what we call it. That's what they say on the news all the time. Now, the second question is, why should we stop with educated people in England, for example, or Anglo-America, which is what he was basing it on? If we were to ask devout Muslims what law is, many would point to state law. Sure, they're familiar with that. But many would also point to the Sharia. If we were to ask people in rural parts of Asia, Africa, and the Pacific, what is law? Many would first say customary law is law. And then they might say, well, state law is law as well. Now, analytical philosophers left all this out in their inquiry with no explanation or justification of why it is we fix on this form of law and not take into considerations what others think of law, and what others think of law as the core case of law. Now, what makes their theory up, so that's why it's incomplete. What makes it obsolete is that the theories of law that they've come up with have really actually never been true, or at most been true of a very limited, in a very limited period of time in a very limited location. So let me give you the general idealized theory of law that they produce, and that's the idea of the unified state system supreme within the territory of the state. Hart asserted, for example, that legal systems contain an ultimate rule of recognition, and this was necessary for the uniformity of the system. Raz identifies three essential features of legal systems. One, they claim to regulate any type of behavior. Two, they claim supremacy over all other normative systems in society. Three, they maintain and support other forms of social grouping. I quote, "By making these claims, the law claims to provide the general framework for the conduct of all aspects of social life and sets itself as the supreme guardian of society." Now, the problem is that this image of law, though common enough today, is actually a fairly recent one, which became entrenched only in the past 2 centuries. Law in medieval Europe was a jumble of different laws and institutions occupying the same social space, lacking any organized overarching hierarchy or organization. These forms of law included unwritten customary law, residual Roman law, codified Germanic customary law, feudal law, municipal law, the law merchant or the lex mercatoria, the law of guilds, canon law of the Roman Catholic Church, royal legislation, and revived Roman law from the universities. Various types of courts coexisted as well. Manorial courts staffed by barons or lords of the manor, municipal courts staffed by leading burghers, merchant courts staffed by merchants, guild courts staffed by guilds, church courts staffed by bishops and archdeacons, and royal courts staffed by the king or his designees. As medievalist Walter Ullmann remarked, this complex mosaic of legal systems presented many difficulties to the application of abstract legal rule to the given set of circumstances. And this is because courts actually claimed overlapping jurisdiction. Max Weber observed, the result was the coexistence of numerous law communities, the autonomous jurisdictions of which overlapped. The compulsory political association being only one such autonomous jurisdiction insofar as it existed at all. It turns out that what analytical jurisprudence take for granted as truisms of law are contingent and relatively recent developments. Their idealizations about the supremacy and uniformity of law, furthermore, have never been true of many countries in the world, particularly in the global south, where alternative forms of law have continued to exist to this day. Let me just give you a timeout. I learned this lesson on the ground as a lawyer when I worked in Micronesia. And I went to the outer islands, the representative of law for the government. And I go to these islands that have no legal presence, that have personal injuries, property, all the same things. And it was managed entirely based on customary law. And it was a lesson that I learned by being confronted with the reality of this. So when I came out there as the law, their response to me is, well, we have law. So I said, okay. So now I'm trying to describe for you that this is an idealization, and it has never been accurate, except within a limited span of societies, obviously the developed North in particular. But what makes the theories of law obsolete is really the phenomenon of globalization. Hart articulated his concept of law at the peak of the consolidation of the political and legal power within the state. And this was in the mid-20th century. This was marked by a centralizing dynamic that tied together economic, political, and legal phenomenon and activities within nation states. In the current period, this unification, and we're all talking about it, within the state is pulling apart in various ways. Significant political and legal powers devolve downwards and upwards away from the centralized state. By downwards, I mean things like Scotland, I mean the Kurds in Afghanistan and Iraq, in Iraq. By upwards, I mean regional and transnational bodies that exercise more legal and political power. Now, I don't want to exaggerate the implications of these developments. The locus of political and legal power remains within the state in most countries, with the exceptions of chronically weak states and war-torn societies. That said, political and legal authority is divided up in ways that make claims of supremacy and uniformity of law increasingly untenable. And you know as better than I do that the European Union is a great example of that. Debates now about constitutional pluralism are a major topic in the European Union, precisely because they're competing not just content of law, but which jurisdictions get to hear the case, and when they do hear the case, which decision is supreme. And it's being managed in a rather pragmatic way, which is avoiding direct conflict, but nonetheless, the uncertainties entailed in this continue. So this was the second reason I believe it's going to change. The first is that the logic is unsustainable. The second is that it's not descriptively accurate anymore. It doesn't capture the nature of law in the world. Now let me give some very quick signs the change is already occurring. The first is that I think the younger generation of analytical jurisprudence are talking about law in a different way. One example I'll cite is Keith Culver and Michael Gudici's book, Legality's Border, in which he talks about what they call interlegality, the interpenetration of legal systems, things developing into legal systems or halfway through them. In another book that's coming that I read an advanced draft of, they build on the arguments of legal pluralism to mount a very serious critique of the presuppositions held by Rawls and some of his followers. Let me also add Max Del Mar's work, which I think does the same. It shows this real intense care for analytical analysis and yet begins incorporates sociological insights in various ways. Now, what marks these works, as well as others, is, again, their commitment to the analytical component of it, and yet their openness to thinking about law in a different way, and in particularly about the plurality of law. A more powerful sign of change, though, that I want to focus on comes from Joseph Raz himself. In a recent essay, Why the State, I was astonished when I read this essay on SSR Ren a few months ago. The thrust of it goes against what he's written about for several decades now. Raz, I quote, is critical of jurisprudential theories that focus more or less exclusively on the state. Owing to changes in the wake of globalization, he urges legal philosophers to break out of this narrow view to examine what he calls other kinds of law. As example of types of law to be examined, he lists, I quote, international law or the law of organizations like the European Union, but also canon law, Sharia law, Scottish law, the law of native nations, the rules and regulations governing the activities of voluntary associations or those of legally recognized corporations, and more, including many transient phenomenon like neighborhood gangs. Please indulge me as I ask us all to pause for a moment of silence to contemplate the significance of these statements. I hope I don't sound overly dramatic when I say that this essay marks the passing of an era in analytical jurisprudence. For three reasons, I believe the ground has irrevocably shifted. First, Raz himself has heretofore focused exclusively on the state in his theorizing about law, talking about the state as the core form of law, not denying that others exist, but basing his entire analysis on state law. His influence among legal philosophers, added to Hart's immense influence, undoubtedly has contributed to the exclusive focus on state law for the past 3 generations. He doesn't mention his own role in perpetuating this narrow focus, nor does he mention that others like William Twining, even Neil McCormick, have actually decades earlier broken out of this central focus. But it doesn't really matter. By making this statement, by broadening the inquiry to include other legal phenomenon, which is long overdue, there's no going back. The second reason this essay is crucial is that it completely undermines their arguments, already questionable arguments, about essential, necessary, and universal truths about law. All along, these arguments, these claims have been grounded on a singular concept of law based on state law. Now Raz has opened the field to other kinds of law. The problem is that the other forms of law he mentioned do not share the same characteristics. Each comes in a range of variations. They change over time, like state law does. Adding other forms of law to their plate for philosophical analysis raises previously unasked questions. Does each form of law produce essential, necessary, and universal truths about law? Or do only concepts of law derived from the state provide this basis? And if so, why? Now, this does more than open up new questions. By implication, it challenges their previous core assumptions, which were uttered on the assumption, on the basis that only one form of law exists. The third reason this essay marks a crucial change brings me to a point Professor Cotterrell has been arguing for decades. Time and again, he's urged legal philosophers to pay greater attention to empirical studies of law. Until now, legal philosophers have based their analyses of law largely on their intuitions about state law. Well, that no longer suffices. If they're going to expand their focus to include other kinds of law mentioned by Raz, like religious law and indigenous law, they must learn about these forms of law. And to learn about them, they must read sociological and anthropological accounts. There's no other way. And when they delve into the abundant sociological literature on other forms of law, they will soon learn the situation is exceedingly complex. As I said, there are different manifestations of religious law inside and outside the state. There are different manifestations of customary law inside and outside the state, hybrid versions of all of this, differences that make it very difficult to satisfy their self-proclaimed methodological strictures. Welcome to the messy world of social legal theory. Let me move to the second part of the talk, and that is giving or mapping out jurisprudence in a way that I hope brings some clarity for particular purposes. In his essay, Why Jurisprudence is Not Legal Philosophy, Professor Cotterrell situates them as two distinct enterprises. Legal philosophy is tied to philosophy, whereas jurisprudence is tied to juristic issues. They overlap in the sense that the object of focus is law, but other than that, they're very different. My characterization of the relationship between these approaches is different from his. In my view, there's no correct way of doing this. So we're just mapping out jurisprudence in ways that are useful and illuminating. So I'd like to offer a different view in the suggesting that it has there are some benefits to seeing it in these terms. In my view, jurisprudence is a broad umbrella term that encompasses all theoretical perspectives of law. And in that context, many of these theoretical perspectives, I believe, can be placed in one of three schools: natural law, analytical jurisprudence, and social legal theory. So let me offer some historical and theoretical reasons for thinking about jurisprudence in these ways. For historical reasons, it was simply the common way that they thought about jurisprudence a century ago. Roscoe Pound wrote in 1911, "Until recently it has been possible to divide jurists into three principal groups, according to their views of the nature of law and the standpoint from which the science of law should be approached. We may call these groups the philosophical school," that was what they called natural law, "the historical school, and the analytical school." John Salmon presented the same breakdown. He said, "Jurisprudence in its specific sense as the theory or philosophy of law is divisible into three branches, which may be distinguished as analytical, historical, and ethical." Julius Stone also divided jurisprudence into three main branches, which he labeled analytical jurisprudence, sociological or functional jurisprudence, and theories of justice or critical or sensorial or ethical jurisprudence, which was natural law. So it was common to divide them into three different branches. But it's not just useful as a theoretical matter. As a historical matter, there's useful for theoretical purposes, but let me just clarify one point. They use two different terms, historical jurisprudence and sociological jurisprudence. In another piece, which is called the third pillar of jurisprudence, I make an argument that although they go by different names, they're different streams or different branches, different versions or variations of the same branch, and this goes back to Montesquieu, comes up through historical jurisprudence, sociological jurisprudence, legal realism, all the way up to the present. And the basic idea behind social legal theory, shared by all of these schools of thought, is that law is a social institution. It takes social forms, has social consequences, it changes along with changes in society, and is deeply interconnected to the surrounding political, economic forces. So although in some cases they call it historical and others sociological jurisprudence, I'm suggesting that these are just siblings within the same branch. So let me explain quickly why I think this theoretical division makes sense. Each of these three different schools takes just a different angle. And by angle, I'm saying they're not mutually exclusive, but it's the direction from which they're coming at. So natural law takes a normative angle on law. Analytical jurisprudence takes a conceptual or analytical angle. Social legal theory takes a descriptive and empirically oriented angle. Or to put it in another way, natural law is grounded in moral philosophy, analytical jurisprudence in analytical philosophy, and social legal theory in empirical social science. And by science, I mean this very broadly, expansively to encompass history, sociology, economics, anthropology, psychology, political sciences, anything with an empirical orientation. Now, again, I want to emphasize that angle means that they have their own distinctive center, but they're not mutually exclusive. And when not pushed to antagonistic extremes, these three orientations balance one another. Salmon stated, "These three aspects of law are so involved with each other that the isolated treatment of any one of them is necessarily inadequate." Morris Cohen declared, "No great individual jurist ever belonged exclusively to the analytical, historical, or philosophical school." All three, they're different, but all three have normative implications. All three engage in conceptual analysis, and all three accept that law is a social institution. So the argument I'm making is that we actually need all three, that they all bring something different. They all bring a different approach to law. And that while different, they're also complementary to one another when seen together. So my breakdown differs from Professor Cotterrell's. He wants to send legal philosophers off to join other philosophers. I want actually social legal theorists to have a seat at the same jurisprudential table with the other two. Now, you might not think it's necessary to make an argument that social legal theory should be recognized at the jurisprudence table. But alas, it must. Brian Bix's, who's a friend of mine, by the way, and I every time I see him, I jab him at this. His otherwise encyclopedic jurisprudence theory and context text spends only half a page on historical jurisprudence, basically noting its demise, mentioning Maine and Savigny and saying it died a long time ago. He doesn't discuss sociological jurisprudence at all. Raymond Wax confides that a legal philosopher who reviewed the pre-publication draft of his jurisprudence book urged him to eliminate altogether the chapters on historical and sociological jurisprudence because, I quote, They were mainly empirical and insufficiently intellectual. So apparently they want to kick us out of jurisprudence, and Roger wants to kick them out. Can't we just get along? I'm sympathetic to Roger's side, but I actually believe we're collectively better off by seeing this as a broad tent. And when I teach jurisprudence, I teach all of the schools, and I actually think it's beneficial to see that. And one of the reasons it's worth arguing for is that apparently legal philosophers don't teach sociological jurisprudence in their courses, and I think it's unfortunate because they're missing out. And let me just give you an example of why they're missing out. As I said, for decades, legal pluralists, Roger has written about this, William Twining, have talked about other forms of law, and had Joseph Raz actually paid attention to that decades ago, legal philosophy would be different today, because they would have been talking about these other forms of law, and it would have changed the nature of what it is they were examining, and that would have forced changes in the way in which they were talking about it. Now, if the past 4 decades is any guide, there's every reason to expect legal philosophers will continue to think their conceptual work on law is special and superior to what natural lawyers and what social legal theorists do, and in my view, that's okay. In truth, theorists who work within each of these 3 branches believe their work highlights what's truly significant about law. This is why we have chosen to engage in our own particular theoretical perspective. Okay, let me move to the last. I'm beginning to go more quickly because I don't want to tax your patience. But I'm moving to the last part, and that's what I call a theory of law for the modern age. So let me describe this perspective. It's something that I'm trying to develop. And this perspective, I've already identified what I believe is the core of social legal theory, which is the simple idea that law is a social institution. It changes in form and function over time. It has different forms and functions in different social contexts. As society becomes more institutionalized, organized, and specialized, law has become more institutionalized, organized, and specialized. The evolution of society and the evolution of law are 2 sides of the same process. To kind of encapsulate it, it's the idea that law is a social growth. To give you a sense of what I mean, I'm going to summarize 5,000 years of social legal development in about 3 minutes. Now that's ridiculous, but here I go, and I have to talk quickly because I only have 3 minutes. So early on, when humans lived in hunting and gathering bands, law at its most rudimentary established protections relating to protection of property, persons, and family unions. Law addressed the basics necessary for physically vulnerable social beings to live together, procure adequate food and shelter, survive, and reproduce. Sanctions were enforced by the group as a whole. When communities settled to engage in agriculture and herding, they increased in size markedly, forming complex chiefdoms in early states. Legal institutions coalesced as an aspect of social complexity. More laws were recognized to deal with more forms of property and transactions. Structure and organized force became aspects of law, creating legal systems. This new stage was a kind of phased transformation after which law acquired a different form and set of capabilities, most importantly, coercive power. Legal systems continued the basic functions of law in the first stage, related to hunter-gatherer bands, that's property, persons, family unions, but it also took on new roles. Law also structured and enforced social, economic, and political hierarchies. And law enforced the power of the polity as well as of the legal system itself. Law was clothed in religious and political ideology, tradition, and community norms. States that became empires conquered nearby neighbors in faraway lands. They utilized law as a coercive mechanism to maintain imperial domination and advance imperial economic concerns. About 3 to 4 centuries ago began the slow process of the consolidation of the state system with and through law. Legal systems underwent further institutionalization, entrenchment, and rationalization within organizations tied to the states. This ultimately became law as we know it today. This involved a second phase transformation. Law is no longer mainly focused on social ordering functions. Now law is created at will and has become a multifunctional instrument backed by organized coercion, utilized by individuals and governments to pursue unlimited purposes. The latest stage of the social growth of law involves the institutionalization of law between states and across states, matching growing networks of political and economic activities that cross state boundaries. So that brings us to the present. And what I mean by phase transformation, I mean there's a continuity going on through all of these stages, and yet at each stage, law is taking on a different form and function and set of capabilities. Think of the first phase transformation in Hart's terms. This was the period in which Hart's secondary roles crystallized. Or in Weber's terms, this was the period in which they developed coercive staffs of people prepared to exert coercion. The second transformation is really about the enhancement of the institutional capability of legal systems within government. And it's in this second transformation that law became instrumental, ultimately instrumental in its orientation in ways that could be used to pursue limitless purposes. Okay, now when I talk about it in these terms, I want to correct a misleading impression. It sounds like a historical trajectory with later stages replacing the first, but that's not what's happened. What's happened is that all of these forms of law coexist today with interpenetrations. That's what legal pluralism is about. You will find forms of customary law that still exist, fewer and fewer as time goes on, but they still do exist. I saw it. In areas of the world, you'll find interpenetrating systems of state law and customary law. You'll find, obviously, transnational economic law. So they all exist. So there is a historical piece to this, but it's one in which residual components of all of these continue to exist today. Okay. Now let me say why theories of law, the typical theories of law that we use, are inadequate to modern law. My basic argument will be that theories of law focus on law after the first phase transformation, but fail to account for law in the second phase transformation. Now, to set this up, I just need to talk about the world we live in today, which we just take for granted. The standout feature of modern society is organizations. Society today is dominated by organizations. Multitudes of organizations and networks between them maintain daily life in cities. Think about it. We work for organizations. We were educated in organizations. Many of our actions are channeled through organizations. Or think about the neighborhood grocery store. Goods stocked at the store arrives, gets there from places around the globe through the efforts of countless numbers of people working in organizations engaged in growing, processing, buying, selling, transporting the food. Sociologist Dennis Wrong describes contemporary social order as an interconnected weaving of networks and organizations. I quote, "Dependence on heat and light and supplied by electricity, on plumbing linked to water supply systems, on automobiles, roadways they require, on telephonic communications, on regular garbage collection and disposal, to mention only the most obvious examples, long predating the products of recent electronic technology, binds people to myriads of others in far-flung system networks." Now, what does this have to do with law, you might be wondering? Well, if law, or since law, is intimately connected with society, it follows that state law, which is what I'm focused on here, has been deeply immersed with the rise of organizations and has been reshaped by the same forces. I'll identify quickly just three ways in which law is tied to these developments. One way is that law directly participated in and played a major role in the rise of organizations through general laws of incorporation. It's through general laws of incorporation have a kind of magic to them in that they bring organizations to life. And by that, I mean literally that many of these organizations will outlive the people who created them, outlive the people who have owned them, and the people who work for them. That's one. A second way that law provides is that law provides the background structure for the activities of organizations. I'll get back to that later. The third way is that state law itself consists of a complex of organizations that operate as a subset of government organizations. They're internally organized and run as bureaucracies, the same as other bureaucratic organizations within society. And state law plays a special role within government organizations to help advance the objectives of the government. Okay, so this is where I believe modern legal theories have a blind spot. The blind spot is they fail to take fully into consideration the role that law plays as an organization, state law in particular, within government. The reason for it is that when theorists ask the question, what is law? Their aim, and you'll see this repeated in many of the discussions, their aim is to distinguish law as a form of social ordering. And they say, well, how is law distinct from etiquette, custom, and morality, and religion, and games, for example? Now, this framework leads them to develop theories of law that center on social ordering, leaving out a great deal of what law does that has nothing to do with social ordering. So let me use the theories of Hart and Fuller to show this. Although they were theoretical opponents, they actually shared the same basic framework. Fuller described law as, quote, the enterprise of subjecting human conduct to the governance of rules. The first desideratum, he wrote, is that there must be rules. Similarly, Hart identified the character of law as a means of social control, and as he famously, and in my view brilliantly, reduced law to the union of primary rules of obligation that apply to social behavior and secondary rules that tell us how to run the primary rules. He stated, while primary rules are concerned with the actions that individuals must do or not do, the secondary rules are all concerned with the primary rules themselves. Now, as I said, the problem with this is that law does many things that neither involve social ordering nor entails rules. So let me give you an example. The general laws of incorporation that I already mentioned, and laws empowering administrative agencies. These are different versions of enabling acts. These two types of law have created the two behemoths of modern society: government agencies, that everyone laments, and corporations, that lots of people lament. Now, these are structured, these are created by law. Now, let me give you another example, and neither of which can be said to be about social ordering or the enforcement of rules. But let me give you another example, and this is a multi-sided example. I'll have to use the United States as an example because I don't know which institution does it in the UK, or every place is different. But the example is money. Government uses law in various ways to create money. In our country, that's the Legal Tender Act. To issue money, in our country, that's through the empowerment of the Federal Reserve. To acquire money, taxation, we all share that one. To borrow money, that's authorizing bond issues and raising the debt ceiling. And to spend money, that's appropriation bills. Now, none of these bills, none of these legal actions involve social ordering, and none of them involve rules. This is just about using law as a way to get things done. So any concept of law that's based on the social ordering function of law won't be capable of incorporating these other aspects of what law does. And this is what I meant when I said that legal theories really have focused on that first phase transformation. Law is the course of enforcement of norms. Law is secondary rules attached to enforcing rules, obligatory social norms. Okay, I'm sorry for going quickly, but I do want to get to the end. So I'm going to very quickly suggest a different way of thinking about law that will bring some of this into focus. So the first way, so this is about two orientations. And I call them orientations. They're not mutually exclusive, but they're ways of looking at what law does. One orientation is the law specifying the background rules for social intercourse. That's the first unit of law that we're all familiar with. And this is about contract, property, personal injuries, torts, commerce, marriage obligations, and so forth. All entities within society, individuals, corporations, government agencies themselves operate within this context of background rules. The second orientation is law as an arm of government. In this orientation, government uses law in particular ways to accomplish particular objectives. So I want to just specify three different uses. Analytically, it helps to see them as different. The first use is that there are laws that support government organizations themselves. The obvious one is taxes. Think of government as an organization that needs resources. It gets those resources, not through consensual people providing them, through imposing it coercively. Another example are sedition laws that are used to quench rebellion. The second use of law is laws enacted by the government to pursue objectives. Think of laws related to pollution, to health, safety, transportation, the economy, and so forth. Laws creating corporations are a version of this because they're done for economic purposes. The third use of law involves application of law in the internal operation of government itself. When government uses law, law has declarative, performative, directive, and communicative capacities that are utilized to create, structure, fund, and run government organizations. The government uses law for this simply because it's a handy way to do it. You declare it, and then it becomes a law, and government officials follow it. Now, the basic difference between these organizations is that background rules are basic to social life, and as I said, go back thousands of years, whereas government uses of law are tied to government organizations and their activities. And actually, this is a modern creation, because these uses of law could not come into play until government organizations developed the capabilities to declare law in an effective way, in a way that was then carried out, which relies substantially on organizations, on the organization of law. So this second part is a much more recent development. Now, let me offer another way of distinguishing them, and this comes from Friedrich Hayek. Background legal rules really limit the range of permitted action, but don't determine a particular course of action. They're not about pursuing any particular purpose, although they have functional benefits. They're not designed to achieve aims. Whereas government-related law, they're actually aimed at carrying something out, achieving some objective, although often failing. Now, another way to mark the difference is that background rules, related to this, is they're not instrumental in nature, although they're functional. And government uses of law, in contrast, are thoroughly instrumental. Okay. I think I will skip the next section by very quickly making a statement. If you look at the second transformation, I want to suggest, and I'm arguing for this in a book I'm working on now, that if we look at Henry Main's famous thesis that law moved from status to contract, from based on family relations, kinship, and status to contract, in many senses, we believe we're still in the contract stage because we see contract-based relationships. And the argument I'm making is that we've actually moved to a third stage with the age of organizations. And that third stage is often referred to in the social legal literature as juridification. And by that, what I'm going to suggest is that many legal arrangements in modern life are actually, they look to be contract-based. But if we think of contracts as relationships freely entered into, and the terms of those arrangements freely decided upon, that's not, in fact, how our society operates. In reality, everything we do is based on preset, often formed contracts. You open a bank account, take out a lease, buy a house, everything. Whatever you do, all of these often say, sign on the form below, and even as a lawyer, I hesitate for a moment, and then I don't read and I sign anyway. And the reason you don't sign is because you don't actually get to negotiate those arrangements. That's how it is. So this is a different kind of arrangement. And in fact, this has resulted in legal bundles. And some other sociologists of law have been writing about this, how law is becoming commodified. Instead of legal services, they're becoming legal products. In the United States, you can download pre-written wills, papers of incorporation, contract forms, employment contracts from the internet for a fee, a very small one. And all you do is fill out the bottom line, and if you have any questions, there's a call-in person on the other side you can get a hold of and ask. Now, in addition, so this is one set of preset, but we also, through the instrumental uses of law, have all sorts of restrictions, zoning laws, health and safety regulations. We also have tort law, creating incentives based on liability. So my suggestion is, and this is me talking about the phenomenon of juridification, this is a new stage, obviously in these developed economy societies, in which law actually forms a more or less preset background. Now, aspects of this legal web, I call it the legal web, are being contested at all times, but not the whole. So we can fight over labor rules, labor and employment rules. Pieces of it can be changed and are actually constantly changing in relation to social, economic, and technological changes. But the web itself is fixed and stays there in a relatively steady form. Now, I want to emphasize that any piece of this could have been different. Property didn't have to be broken up into fee simple, life estate, remainders, leaseholds. But once it was broken up that way, society and social arrangements became encrusted around this in a way that everything incorporates these baseline legal provisions into their operation. So much that although parts of it can be changed, to think about changing it would be impossible because it would be enormously socially disruptive. And so where I'm going with this is, assuming some unimaginable catastrophe, I believe this baseline legal web is here to stay. It's a part of what is deeply integrated within our societies and is a part of what we're based on. And let me just add one last thing about juridification. It's often talked about as scary terms if it's choking us up. And in some ways it feels like that when you have to fill out all these forms. On the other hand, it provides a very important function in modern society, and that function is trust. Think about how often each day we interact with strangers on virtually everything we do. Well, in societies long ago, trust was based on relationships. But today that's not possible other than in small circles of people. So all of us engage in all of these transactions, from buying a ticket to the metro to taking out a lease, with the implicit assumption that we rely upon that legal arrangements are in place. And if it goes badly, well, it'll be taken care of, or at least I have some recourse. So that's what's provided by the background legal web. Now, I'm talking about our societies in particular. Now I'm just talking about the global north. And what I want to suggest is that we can comparatively look at other societies and examine the extent to which this background web exists in their society. In some societies, only in the cities. And even in some of those societies, only in part of the cities. For example, if you think about the favelas in Brazil, that legal web doesn't exist in the favelas. They don't have official title to their property. They don't have running water and sewage. They tap electricity from the lines. So they live outside of this legal web. If you think of the countryside in the Pacific, in Africa, they live almost entirely outside of this web. Societies differ in the extent to which the existence of this legal web is there. Okay, I'm sorry for taking so long, and I appreciate you listening. I want to say a few words in conclusion. First, about this view that I've just outlined. I actually don't believe that this theoretical framework covers everything and is good for everyone, and there are lots of reasons not to like it. I just think it's useful, and I'm trying to develop in a way of us breaking out of the ways in which theories of law tend to focus just on that social ordering function. So let me return to, in conclusion, let me return to the title, The Future of Jurisprudence. And the future for me is always, well, the next 20 years. What do we know beyond that? So I expect jurisprudence will mainly consist of the three branches I identified, along with a bunch of other miscellaneous schools that don't fit in. But about these three branches, natural law will continue in the vein of moral theory with close links to religious sensibilities as well as moral philosophy. Analytical jurisprudence will change for the reasons I detailed, to take up other forms of law, to focus on interlegality. But I have no illusions that this change will be substantial. My focus really is on sociological jurisprudence. And I will optimistically state here, although currently written out of jurisprudence texts, except for Raymond Wax. Thank you, Mr. Wax. I'll write to him one day. I believe that this will become the most robust branch of jurisprudence. And the main reason for it is that it comports with the modern sensibility towards greater use of social science to expand our knowledge. And if you look everywhere, and this is happening in law as well, but just not in jurisprudence proper, right? Empirical studies, data, this is the order of the day. So far, it's kind of been kept out of jurisprudence, but obviously not of social legal theory, which has been carrying on. So that's one piece of it. It's the nature of knowledge now that it seeks out empirical information about law and legal institutions. But there's another reason why I believe it will be the most thriving version of the three, and that's because social legal theory really bears on the issues of the day. It talks about the things that people talk about. It talks about the things that Roger wants us to talk about. And so in this coming generation of jurisprudence, I believe the extraordinary work of Roger, Professor Cotterrell, who's done, in my view, more than any other single theorist to lay a sociological foundation for the sociological study of law. And I believe, finally, he will receive, and his work will receive, the recognition that it richly deserves within jurisprudence. Thank you.